Hello, this is Attorney Brian Pendergraft, and this is the law on breach of lease in Maryland. And what you see on my screen here is Maryland Real Property Code 8-402.1, and that is the statute that governs and sets the rules for breach of lease actions in Maryland. That said, I have to give two quick disclaimers. One, this is legal information. This is not legal advice. Although I am an attorney, again, this is legal information, not legal advice. And two, as of today, it is October 26, 2019. And that is the version of the statute that I am. This is the latest version that I could find. So if you're watching, the law changes. So if you're watching this after October 26th, I don't expect to change anytime soon. But hey, it could change tomorrow. So, it's just something that you should be aware of. All right, so I'm going to, and if you want to follow along, I have a link in the description for Maryland Real Property Code 8-402.1, so you can follow along yourself. So, that will bring you to this page, the one that I'm looking at here. Except the difference is my version, it's color coded actually. It's kind of highlighted, so I can. It just helps me kind of focus on and different parts and jump around. Of course, your version won't be highlighted. So mine's just kind of highlighted for my own convenience, and it kind of makes it easy for me to explain. So that being said, so we're starting with 8-402.1, section A1I, which states where an unexpired lease for a stated term provides that the landlord may repossess the premises prior to the expiration of the stated term. If the tenant breaches the lease, the landlord may make a complaint in writing to the district court of the county where the premises is located. So essentially what this orange portion here, this says that essentially the tenant they're still under lease, and the landlord wants to evict them for breaking a term at least. Say, for example, they have a dog or something like that, and they're not allowed to have dogs on the property. They can make a complaint in writing to the district court where the county of the county where the property is located. So the district court is the venue. So if you are in not circuit court, not probate court, this specifically says that breach of lease is in the exclusive jurisdiction of the district court. So if you are in, say, for example, Prince George's County, you need to file in Hinds with the district court. If you are in Montgomery County, you need to file in Rockville District Court. Now, this section that I have in green sets forth, even this red section too, but it's red for a reason. So this sets forth the elements of a breach of lease action. So element number one, the tenant must breach a lease. And two, the landlord has given the tenant 30 days written notice that the tenant is in violation of the lease and the landlord desires to repossess the lease premises. Or, and then we're going to skip down here to 3, the tenant or person in actual possession of the premises refuses to comply. So essentially, when your tenant breaches the lease, you have to give them a 30-day notice saying that we are going to evict you for breach of lease, essentially. So what the courts like to do is they like for tenants to be given an opportunity to cure breaches. They kind of see breach of lease or eviction in general as a very serious remedy. So if you send a 30-day notice if someone has a dog and they remove that dog before you go to court, or you get to court and then the judge is probably going to ask you, where's the dog? Is the dog still there? And if the dog isn't there, they'll probably dismiss the case. Essentially, that's kind of how it works. So they want them to be given an opportunity to cure, and generally 30 days, generally 30. But that brings me to my next point. This section here, this red section B. So you can give 14 days notice in certain cases, but let me go ahead and read this for you. So the breach of the lease involves behavior by a tenant or person who is on the property with the tenant's consent, which demonstrates a clear and imminent danger of the tenant or person doing serious harm to themselves. Again, this is when a 14-day notice is when a 14-day notice can be given instead of a 30-day notice. So let me continue reading. Other tenants. So again, it's talking about in the case of a imminent danger or harm. So let me keep going. So clear and imminent danger of the tenant or person doing serious harm to themselves, other tenants, the landlord's property or representatives, or any other person on the property, and the landlord has given the tenant or person in possession 14 days written notice that the tenant or person in possession is in violation of the lease and the landlord desires to repossess the lease premises. So Again, so this is saying that if in the case of a clear and imminent danger to either the person, to the tenant themselves, to someone who's staying on the property, or to the landlord, or or perhaps one of the landlord's representatives. So that if they're whatever they're doing is that dangerous, then in that case you can give a 14-day written notice. So unless it's I would generally advise a client of mine, unless it's super, I don't know, they're doing something really stupid, really dangerous, you generally have to stick with the giving a 30-day notice. All right, so moving down to this section in purple, this is or pink, this is more so procedural. Essentially, so after you file a breach of lease complaint, the essentially what happens is a summons is issued, and they're told that they need to come to court. So that's the short version. But let me go ahead and read this for you. The court shall summon. Again, this is the court shall summon immediately the tenant or person in possession to appear before the court on a day stated in the summons to show cause. Show cause means that in fact, let me just keep reading. If any, why restitution of the possession of the leased premises should not be made to the landlord. So again, so essentially they can come and they're summoned to defend themselves. So if for any reason the tenant or person in actual possession cannot be found, the constable or sheriff shall affix an attested copy of the summons conspicuously to the property. So they do not have to be personally served. This happens all the time. Tenants may say, oh, I was never served. Well, it was probably posted to the door. Again, but that is how, and that is generally, at least where I practice, that is generally how I primarily practice in Prince George's County. And the sheriffs, they're not really going out the way to personally serve people. Like, they just affix notices to the door. So and again, let's keep going. So 2I, 2 eyes. After notice is sent to the tenant or person in possession by first class mail, the fixing of the summons on the property shall be conclusively presumed to be a sufficient service to support restitution. So again, that's something after you pay the clerk's office. That's something that the clerks take care of. So they'll send the notice by mail, and they have the sheriff fix it to the property. So service is not something that you have to take care of. You just have to pay the fee. All right, so moving on, just a little yellow section here. If either parties fail to appear before the court on the day stated in the summons, the court may continue the case for not less than 6 nor more than 10 days and notify the parties of the continuance. That's not what happens. Practically, that's not what happens. What happens is they just dismiss the case. At least in my experience, when the landlords don't show up, they dismiss the case. If the tenants don't show up, then and the landlord shows up. What generally happens is a default judgment. The landlord probably may be able to get a default judgment, or trial will be allowed to take place without the tenant present to defend themselves. All right, so which usually results in a judgment against the tenant. All right, so moving on to this green section. If the court determines that the tenant breached the terms of the lease, so this is saying, of course, in order for them to make a determination, there needs to be a hearing. So saying that there's going to be a hearing and the court's going to hear it. All right, so let me keep going. The court determines that the tenant breached the terms of the lease and that the breach was substantial and warrants an eviction. So yeah, and as you can see, I have that part here in red because it's worth talking about. So it's not enough for a tenant to breach a lease. The breach has to be substantial enough to warrant an eviction. So there are cases where a tenant may very well clearly be in breach of the lease, or they may violate a lease, but at the same time, it may not be substantial enough to warrant an eviction. So I don't know. They may say something like, my tenant is not shoveling snow, or something like, I have my lease. My tenant's supposed to shovel snow, and my tenant just, I don't know, for whatever reason, didn't feel like shoveling the snow that day. Court may say, yes, your tenant he technically breached the lease. He didn't do what he was supposed to do, but we don't think that this breach is substantial enough to warrant an eviction. So, again, I think the courts view breach of lease or eviction in general, as a pretty serious remedy. So, you definitely want to make sure that, your reasons for, filing for breach of lease are things that can be construed as a substantial enough to warrant an eviction. Like, I don't know, maybe criminal activity, I don't know, pit bulls or some dogs that shouldn't be there, unauthorized occupants. Those sound good. But Anything that is not that serious, you may want to, or you have questions about, definitely consult with an attorney. All right, so keep going. I'm going to keep going. The court shall give judgment for the restitution of the possession of the premises and issue its warrant to the sheriff or constable, commanding the tenant to deliver possession to the landlord in a full and ample manner, as the landlord was possessed of the same at the time when the lease was entered into. The court shall give judgment for costs against the tenant or person in possession. So essentially, this is saying that the court can order the sheriff to restore the property back to the landlord. So in practice, what this means is that, after you have to file what's called a warrant of restitution. And after you file that warrant for restitution, well, assuming you've won the case, right? So you've won the case, so then you can file a warrant for restitution. And then this warrant, essentially, warrant for restitution says that, once the judge signs off on it, that you can evict the tenant and get your stuff, throw him and their things out. But again, you're gonna have to hire your own eviction crew to do that. The sheriff doesn't actually do it. You're gonna have to hire your eviction crew to do that. All right, so they'll be present to make sure that no bad things happen, or that the law is carried out, but they don't actually move things. You're gonna have to hire your own eviction crew. All right, so moving on to this blue section here. So either party may appeal to the circuit court for the county within 10 days from the entry of judgment. So both parties have the right to appeal the decision. If the tenant files within district court and affidavit that the appeal is not taken for delay, file sufficient bond with one or more securities conditioned upon diligent prosecution of the appeal. So generally, tenants have to pay an appeal bond. It's probably calculated based on, or at least in my experience, judges like to calculate it based on the monthly rent. So they may say, it's going to take about 3 months to get into court again to get for this to be heard in circuit court. So the appeal bond may be 3 months rent. But again, don't take my word for it. Judges are weird. They kind of do different things. This was saying file sufficient bond for one or more securities because amount to prosecute the appeal, pays all rent in arrears, all costs in the case, and pays all losses of damages which the landlord may suffer by reason of the tenant's holding over. The tenant or person in possession of the premises may retain possession until the termination of the appeal. So this is saying that the tenant, as long as they pay their bond, they're allowed to maintain possession until the termination of the appeal. And upon application of either party, the court shall set a day for the hearing of the appeal not less than 5 or no more than 15 days after the application. So this is saying that how long the appeal it must be heard. 5 or 15 days. I don't think that that's going to, at least in my experience, appeals definitely take longer than 5 or 15 days. But all right, this is what the law says. A notice of the order for a hearing shall be served on the party at least 5 days for the hearing. Judgment of the district court is in favor of the landlord. A warrant shall be issued by the court, which hears the appeal to the sheriff, who shall execute the warrant. So again, this is just your tenant or the landlord has the right to appeal, and an appeal date is going to be set, and a bond may be set, and the tenant is going to have to, and they can stay in the property so long as they have paid that bond, and another hearing will be heard in the circuit court. All right, so moving on to this orange section. Acceptance of any payment after notice but before eviction shall not operate as a waiver of any notice of breach of lease or any judgment for possession unless the parties specifically otherwise agree in writing. So in other words, the tenant can't necessarily pay and stay. Again, this isn't, breach of lease generally isn't about payment anyway. There's another cause of action for that. It's called failure to pay rent. So that's another thing that so don't file for, I guess not paying rent is technically a breach of lease, but there's a failure to pay rent action, and the courts are going to tell you to file that. If you ever don't file for breach of lease for unpaid rent, your case is going to get thrown out. That's what failure to pay rent is for. But this is saying that again, if a landlord were to accept money from the tenant after this judgment has been received, they have not waived their right to throw out the tenant. That's what that says. So so the tenant can't just say, "Oh, I paid. How come he's throwing me out?" That's not how it works. All right, so moving on to this yellow section here, which is the last section. I guess I found it pretty unimportant, which is why it's Yellow. Any payment accepted that shall be first applied to the rent. So this is any payment accepted shall be first applied to the rent or to the equivalent of rent apportioned to the date that the landlord actually recovers possession of the premises, then to court costs, included court awarded damages and legal fees, and then to any loss of rent caused by the breach of lease. So this is it's saying how rent should be applied. Again, typically in breach of lease cases, rent isn't the issue. That's what fair rent cases are for. Any payment which is accepted in excess of the rent referred to in paragraph 2 of subsection shall not bear interest, but will be returned to the tenant in the same manner as security deposit as defined under section 8-203 of this title, but shall not be subject to the penalties of that section. So again, this is more things on how the rent is going to be applied if they're paying rent afterwards for after a judgment has been entered against them. Again, this doesn't really have anything to do with generally speaking, rent isn't the issue in breach of lease cases. The issue is I don't know, someone having dogs or whatever it may be. Anyway, so that's it. We are done here. We are done breach of lease. So I'm happy I got through it. Hope you guys enjoyed that. So if you guys need an attorney to help you in a breach of lease action, to help defend you, or to help help you get possession of your property back, do not hesitate to contact me. My contact information will all be in the description. Alrighty, thanks for watching.